Please, Your Lordship. Mention in matter WPC 1980-2024 for listing of the
24 matter. When was it last listed?
February.
Huh?
February.
What is the subject matter?
Subject matter was the authority was selected, but yet no appointment was given. And moreover, on this occasion, Lordship, or court directed to file affidavit. So already affidavits are filed, and matter may be listed after four weeks, as per order of the last honorable court. So matter maybe have not come till after February.
Okay, Monday next. Next Monday.
File.
May I please, Your Lordship? My Lord, I beg to mention item number 1 of today's. This matter may be come up after 2 weeks, my Lord. In the meantime, I will talk with my client, my Lord.
2020 matter. How can we adjourn this
Yes, my
matter?
Lord, already the government and SSA already filed their affidavit. They denied that no data entry is found regarding this issue.
2020 matter we cannot adjourn for 2 weeks.
My Lord,
We can accommodate you for 1 or 2 days. We no
Well,
adjournment
well,
for 2 weeks.
it too comes on 7, therefore I am praying for 2 weeks. On 7, my Lord, our Idul Azha will be coming. Therefore, I am praying for 2. Otherwise,
When
will
is
be
Eid?
good.
Today is what? Today is 3rd.
Third.
So still Eid, we have a lot of time.
Thereafter, tomorrow I will went to my native village, my Lord. Thereafter,
How on 11th? On 11th.
always.
A prayer for adjournment has been made on behalf of the petitioner to seek instructions. Have you, yes, other side. Okay. We have it. Para. As this matter is of the year 2020,
On 12th, my Lord.
a slight adjournment is granted directing this matter to be listed on 12th.
12.
Okay, 12. 12/6.
Always.
Wait, please. So I
12/6
think to
is
mention item
Thursday.
number 9, Malad, the orders for 9 to 35, Malad. Here
Yes.
I need to file an affidavit, Malad. So I have informed the other side.
What will you do for the whole day? These are the list. 9 to
9 to 35, Malad. All are similar, Malad.
we are prepared with that matter. We thought we'll hear one matter in details. Rest the issue is all the same.
Issue is same other way. But
You have not filed affidavit in any matter.
in other matter, we have filed one. There's a recent repetition, Malad. So item number 35.
Your affidavit in the other matter will cover, will make an order.
But there are some subsequent development also, Malad. That is why, Malad, I want to
Yes,
consolidate.
Madam Bora, Borakur.
See, we have a person, but they have no time. If they have RDR also, they
Okay.
have taken time out.
3 NJ Khatonir Leonard, Standing Council,
Sending out.
Secondary Education
Elementary
Department, Elementary Education Department submits that an affidavit is required to be filed, for which he prays for some time. Accordingly, these matters are adjourned by
Immediately after, Malad, summer vacation, Malad.
adjourned by
Your Lordship, pick the date.
by 3 weeks to enable filing of affidavit by the department. Full stop. As requested, list on 16th of July.
Obliged.
Lord, in that series, one item has been left out, but may I pray WPC number 4775 of 2020?
Connected, Mr. Khatonir.
Yes, Malad.
List. The WPC
4775 of 2020.
4775 of 2020
2020.
may be tagged in this series.
Obliged.
Yes.
May I please? Lordship, I beg to mention item number 36, Lordship.
Yes.
Lordship, the conducting counsel, Mr. A.R. Boya, he is not present today, Lordship, due to some health issues, Lordship. So matter may be passed over.
37.
Yeah, 36, Lordship.
36. All matter.
Yes, Lordship. They are also, otherwise the education department is also supposed to file affidavit, Lordship.
No, affidavit will not allow affidavit to be filed after 10 years.
Right.
36.
Right.
What is the matter? Why is there any life cause of action? 2014 matter. 2014 matter. Mr. Khatonir.
Yes, Malad, the 14 matter, Malad.
We cannot adjourn 14 matters.
Sahidul Amitam. Sahidul Amitam.
We'll have this on Friday. Friday, if he's not well, you make some alternative arrangement. Today we are accommodating on because of health issues.
Obliged, Lordship.
14 matter. Okay.
Obliged, Lordship.
A prayer for adjournment has been made on behalf of Sri A.R. Bhia on health issues. Full stop. There are private respondents also. Have you informed them?
I have tried to contact with them, Lordship, but they
Trying will not be enough. You have to wait. Trying will not be enough. Without information, without consent, we cannot adjourn. Yes, next.
Obliged, Lordship.
You will be here when the matter is called upon.
Is quiet vision, item 2.
Matic.
Yes.
My lord, this matter regarding my lord, pension, and it is my lord, his pension was delayed. due
You have
to,
got
my
the
lord,
service book, madam?
What?
Service books he has got obtained.
Yes.
Yes. What is your case?
My lord, the case is that my lord petitioner before your lordship ought to have been given retirement, my lord, on 31st January 2018, but he was given retirement, my lord, in the year, my lord, November 2021. That
You overstayed.
overstayed. Thus he, my lord, overstayed, my lord, almost 46 months.
Yes.
My lord, he being confused, my lord, when he joined in the service, my lord,
You retired as what?
my lord, assistant teacher, my lord, LP school. And he was working, my lord, sometimes for the post of headmaster of the LP school.
Okay.
My lord,
Now you're from the pensionary benefit, there has been deduction.
no, my lord, they are contemplating to redact, my lord, but they are just stay order from the Senate court, my lord. Therefore, my lord, it is not.
Yes, what do you say, madam? What case laws are you referring to?
My lord, here, my lord, when petitioner joined, my lord, in
What case laws are you referring on overstay?
enact, my lord, some judgment, my lord, before the Senate court, my lord.
Annex where?
Yes, my lord, additional affidavit, my lord.
You have to annex judgments.
Yes, my lord.
Since when judgments have become part of pleadings?
My lord, just for my convenience, my lord.
Your convenience, you place the judgment.
Yes, my lord.
You don't annex judgment.
Yes, not that, sir.
You should know the basic principles of pleadings. You're not supposed to annex judgment.
Yes, sir.
Which page?
My lord,
71.
page 71, my lord, this is judgment of the same district, same block, my lord, and referring, my lord, here, my lord, last part of this judgment, my lord. Page 88, my lord, paragraph 20, my lord.
88.
Yes, sir. Paragraph 20, my lord. Consequently, this code, therefore, disposes of both the writ petitions with the following observation and direction. The communication dated 30th.
Where is Rafiq Mashi?
Rafiq Mashi, my lord,
What is the citation?
citation it is,
You don't know.
yes, my lord, it is here refer, my lord.
2015, 4 SCC 334.
Yes, my lord.
Where is Rafiq Mashi? You don't have?
Yes, my lord, page 86, my lord. Yes, it is, my lord. It is quoted, my lord, this judgment, my lord.
2015, 4 SCC 334.
Yes, my lord. And from this judgment, my lord, this paragraph 18 was quoted, my lord, in that judgment.
Yes.
And on the basis of, my lord, this judgment, my lord,
Okay.
and
Yes, madam, what do you say?
This is the second round of petition, my lord. Initially, he has approached this honorable court matter on the same ground, my lord. The order is at page 43, my lord.
43.
43, my lord. Start from, my lord, page 44, my lord. And that was, my lord, withdrawn by the petitioner.
Yes,
Kindly come to me, my lord, page 37, my lord. Why he-
47.
37. Why he has withdrawn, my lord, the reason being,
Yes,
page 37, my lord, para 5, my lord.
yes.
I read
Hmm.
that the deponent denies the apartment made by the made in paragraph 3 of the writ petition. The deponent states that from the report dated 26/6/2022, the block elementary education officer Pasim Nalpari, it reveals that on 23/2/2021, after taking search, he came to know that the service book of almost all the employees were not in the office of the block elementary education officer Pasim Nalpari. Service books were kept in the original in their own custody by maximum numbers of the employee. In this regard, previous CEO issued a letter dated so and so, issue number dated 30/4/2019 to all the employees to submit their service book. But the petitioner ignored the same and did not submit his original service. Subsequently, present block elementary education officer Pasim Nalpari issued another letter to the petitioner to submit the same. Then the petitioner submitted his service book, but without furnishing any document as such as SSLC certificate, appointment letter, deputy certificate, etc. In the report of the PEO Pasim Nalbari, it is also mentioned that due to keeping in the original service book wrongfully by the petitioner himself, his actual age could not be verified by the higher authority, and the PEO Pasim Nalbari was also not able to verify the original documents to calculate the actual date of retirement. My lord, he kept his service book with him, my lord. We have issued letter to him, my lord, but he has submitted in the original. On the basis of the my lord SSLC certificate submitted by the petitioner, my lord, his date of birth was recorded, my lord, 1/1/1965, my lord.
Yes.
Now, after my lord, issuing notice, my lord, he has submitted another, my lord, SSLC certificate, my lord, which reflects his date of birth is 1958. That is in my lord, page 19, my lord.
19.
19. This is the duplicate certificate, my lord, issued in the year 2021.
What is this 19?
19 is the SSLC certificate, my lord,
Duplicate.
duplicate, my lord. Issue date, my lord, on the bottom, my lord, issued on 28/10/2021.
28 and 21. What does it say?
As per this, my lord, his date of birth should be, my lord, 1958.
58.
Right.
Okay.
But my lord, service book was opened in the year, my lord, 2007 on 30.
But why did he give this duplicate date of birth? If his date of birth, duplicate certificate, if as per this service book, his date of birth was 1965, why he will reduce the date of birth to 1958? He does not gain anything.
My lord, because of overstay, my lord, because the petitioner service book was with him, my lord. He has already overstayed for 3 years.
No, so overstay
He
by
should be-
taking into consideration which date of birth?
Date of birth, my lord, is now 19, my lord.
Huh? 19?
By my lord,
No, you say that in the service book, his date of birth was recorded as 1965. So why should he give a duplicate date of birth of 1958? He does not gain, he will stand to lose. What does normally what is the normal practice? One tries to reduce
if my lord, his date of birth.
his age so that he can stay in the service for long. That practice is deprecated by the court. But here, if you say the duplicate date of birth, from that it can be deduced that his date of birth is year of birth is 1958. How does he
He's
gain?
claiming, my lord, he's passed SSLC exam in the year 1976, my lord. If
Yes.
his date of birth is 1965, he's only 11 years, my lord. He cannot appear in the.
No, part is not a 58
76.
and 58.
68.
He
Okay.
was, my lord,
And if it is 65, he will be 11 years.
11 years. And he has submitted, my lord, his signature is also there at the time of my lord opening the service book, my lord. He has signed, my lord, his date of birth is 1/1/1965. my lord.
Yes, Mr. Borovia.
my lord, perhaps, my lord, my lord, indirectly date of birth is given in the certificate. Perhaps, my lord, miscalculated at that time, my lord. My lord, and they have admitted in their affidavit itself, my lord.
No,
that it is-
how your service book records your year of birth as 1965
Yes, sir.
and you had passed your matriculation in 1976.
Yes.
How is it possible?
Yes, my lord, it is not possible, my lord. It is that they have, my lord, they have done mistake, my lord, and it is admitted, my lord, in their affidavit, my lord. That it is, my
Papa
lord.
will come to you. Anything else, madam? You complete your arguments, then we'll come to you. Have a
Yes,
seat.
ma'am.
Yes. What else?
My lord, as per Supreme Court, my lord, if there is no misappropriation on the part of the petitioner, my lord, then only, my lord, we cannot, my lord, recover, my lord. This is, my lord, this is a case where, my lord, petitioner himself, my lord, stated his date of birth is 1/1/1965, my lord. Later on, my lord, he keep his, my lord, service book with him, my lord. After issuing notice to the petitioner, he refused, my lord, submitted the original one. That after then only, my lord, we came to know, my
How much is the amount involved?
17-18 lakh. Because, my lord, similar, my lord, that person was also his.
We'll come to you. We'll come to you. Have a seat. Who listened to did you? By which annexure, by which communication his overstay was detected, madam?
lord, annexer A, my lord, page 72, my lord, additionally 50.
72.
Oh.
Two is a court's order. 70, is it 70?
111.
Triple one.
Triple.
And where is the impugned order?
Yet, my lord, they have not for.
What is this notification of 1/2/1992? Personnel Department?
Very good.
Next is
Next page.
one.
Oh, yes. Here is not a case of overstay simpliciter. He had, your case is that he had initially given his date of birth as 1965, and therefore he was allowed to continue in his service. And it was detected that while continuing in service, that his date of birth is not 1965 but 1958, and therefore he ought to have been retired in the year 2018. And this detection was done in the year 2021, and immediately he was asked to hand over charge. And for this 46 months, you intend to recover the salaries. That is your case. Yes,
The
Mr. Borbia, what, as per you, what is your date of birth?
My lord, 1/1/1958.
58. Then in the entry, service book entry, why was it 65?
My lord, it was, my lord, done by the, my lord, block, my lord. This is true fact, my lord. And my lord, it is, my lord, and he allowed me to sign, my lord. And lord, to kindly, my lord,
No, you are supposed to verify. You are a
Yes, my
teacher. You are not a grade 4 employee. You are a teacher.
he is a very
And
simple-
you see the service book, what is there on the board foot? See, there is a note in the foot. It is verified. I think first page itself, there should be a note. Is there any note, madam? What is the word? Please read it out. Please read it out, if you remember correctly.
The entries in this case should be renewed or reattested at least every 5 years and signature line.
Yes. And not only at the time of entry, it has to be periodically reviewed and signed. You are a teacher, you saw your date of birth as 1965. You did not even approach for correction.
my lord, contributory, my lord, my lord, I cannot say in this way, my lord, because, my lord, this is officer and, my lord, he is a very, in a small rank, my lord, teacher, my lord. It's
You are a
officer,
head teacher. You are not a small rank. Teacher is not
my
small.
lord. But it is, my lord, first, my lord, this duty comes from the, my lord, block, my lord.
That is why the requirement of signature on each page is there. Verification is there.
Yes, my lord.
What did you do?
My
And
lord,
this,
my lord, he misguided, my lord, because this is wrong entry was given. My lord. Officer, normally, he will, my lord, trust on him, my lord. Whatever he has, my lord, highly educated, he has put to be correct. But may not, my lord, see, my lord.
initially,
This
which,
man is, my lord,
Mr.
very
Borbia, initially, which SSLC certificate did you deposit?
Same. just original, my lord. In the meantime, he lost, my lord. Therefore, my lord, subsequently, he, my lord, got, my lord, duplicate. And it was also. And, my lord, as per his content.
So when was it detected? The error or whatever in recording your date of birth, when was it first detected?
My lord, as per, my lord, his pleading, my lord, when, my lord, his 60 years was, my lord, completed. Then, my lord, he, my lord, usually, my lord, used to go to the, my lord, PTO office. And PTO office, my lord, primarily having seen, my lord, this date of birth, he was, my lord, delaying the, whenever he, my lord, insisted, my lord, time and again, my lord. Then, my lord, they come to, my lord, giving, my lord, verbal retirement.
Where have you stated?
My lord, paragraph 4, my lord, he has stated, my lord, how he was confused. Paragraph 4, my lord, page 7, my lord.
Let us see the service book, madam.
Even after, my lord, date of retirement, actual date of retirement, he was, my lord, given, my lord, assignment, my lord, by communication, my lord, issued in the, on, my lord, 2020, my lord.
Yes.
But as per occupancy, if there is no PC provision, what might not a part of. It is a clear case that where the petitioner has separate. Because first matter he signed as part of his date of birth is 1/1/1960. Then now he is saying his date of birth is 25.
No, first tell me, madam, tell us, when was it first detected?
But we have issued notice to the petitioner by the.
When?
On
See,
my
the
lord,
matter has to come to light
Right.
to take some action against him. See, if his date of birth is construed to be 1965, then he has to retire when?
1921.
2021. 21, what notice did you give him?
No, 18, 2018.
Huh?
Retired, my lord.
If it.
No, 65. If it's construed in 65,
Yes.
then what would be the date of retirement?
31st January 2025.
25.
25.
No, when was it first detected? What happened?
My lord, page 37, but
Of the repetition?
of the repeated.
37.
37.
Yes.
My lord, then the DO has taken charge on my lord 2022, para 5.
Yes.
Thereafter, my lord, on 23/2/2021, my lord, he issued notice to all the employee, my lord, because maximum employee do not have the service. Maximum employee kept their service book with their own, my lord. Then, my lord, on
Thereafter, what happened? What happened after this?
34 to
After this detection, what did you give?
on my lord, 38, my lord, last para. 4/8/2021, the PO posting Nalbari issued letter to the petitioner to asking all the authentic document, but the petitioner again ignored the same. Having my lord, having left no other option, my lord, salary of the petitioner was stopped from the month of 2021. Then my lord, the petitioner again remained on my lord 5/10/2021, and thereafter my lord, he has enquiry was conducted, my lord, and enquiry was on my lord 30.
Let us see the report at page 42.
My lord, this affidavit is filed in the earlier case. This report is not.
No, page 42. It is there.
42. May I read my.
Oh, you're reading. Okay. Again, this is. Okay. Mr. Borbia, you gave a wrong date of birth at the time of entry. It was not verified because the service book you had retained. One particular officer was slightly diligent. He asked for service books. You did not give the certificates. Thereafter, you give a duplicate certificate, from where your date of birth appears to be 1958. In the meantime, you have served for 3 extra years.
almost 4 years. 46 months.
46.
Actually, my lord, if we, my lord, practically to go, my lord, it is done by the, my lord, department, my lord. He may have, my lord, some, my lord, contributory negligence is there, my lord. He personally went there and verified the service book and etc. etc. But his primary duty, my lord, is cast upon the, my lord, employer. He has to appoint, he has to release retirement, my lord. And my lord, in their affidavit itself, my lord, they admitted it is mistake done by the, my lord, block. My lord. First, kindly will look in their affidavit, my lord.
Page. Which affidavit?
In this case, my lord, they have filed one affidavit in opposition, my lord.
Page.
Page, my lord, relevant portion, my lord, page 108.
108.
Yet. First part, my lord.
Hmm.
The service book of the petitioner was opened on 30/4/2007, and at that time his date of birth was wrongly, my lord, recorded by the block. Normally, my lord, practically, if, my lord, big officer is sitting and called to sign, my lord, obviously, my lord, he will trust it, my lord. Then whatever he has done is that. Perhaps, my lord, normally, my lord, anybody will not go through all these particulars before the officer to verify, my lord. He should not have so guts, my lord. So whatever entry made by his superior officer, my lord.
Okay.
It is written in the service book. It is as per, according to the SSLC certificate.
And my lord, may I submit another aspect? And my lord, in the, my lord, all the judgment by our court or honorable Supreme Court, principle is that, my lord. Principle is that, my lord, he worked, my lord. Therefore, my lord, he got labor charge. This is the basic principle. And in this case also, my lord, it is undisputed, my lord, on that time, my lord, and my lord, he worked, my lord. Therefore, he got, my lord, as usual, my lord, labor charge. Then it is not salary, my lord, it is only labor, my lord. And
You're not a laborer. You're a headmaster.
that's for
You're saying labor
service,
charge.
public service.
Public service.
Yes, well.
Do it for free.
Yes, well.
You can go to a school and teach for free.
Therefore, my lord, in this regard, I have also enacted, my lord, one judgment of the Supreme Court, my lord. If it is done, my lord, then, my lord, they should have, my lord, taken legal action against him. It is also not done.
You're inviting them to take legal action against you.
Yes, my lord, if they are, my lord, suppose my learned friend is.
Don't be very serious in your submission. Tomorrow they may file a criminal case against you.
Yes, my lord.
You have invited them to
Yes, my
file
lord. My
take legal action.
learned friend is, my lord, saying that, my lord, he did not supply the service book, etc., etc., my lord. If it is not so, my lord, immediately, my lord, superior authority, my lord, disciplinary proceeding, complaint, suspension, etc., etc., was required, my lord. Because he is superior authority, my lord.
Okay, okay.
Lordship, this, my lord, fraud case regarding, my lord, page 59, this is the Supreme Court judgment.
59.
59.
Lordship, now just here.
Oh, 1 second, 1 second. We'll come to you,
Yes.
Mr. Dev. You just let him finish. 50?
59, my lord, this is the, my lord, year 1994. SCC, my lord, 599. Paragraph 3, my lord.
Lalit Mohan. Oh no, what is his name? Narasimha Sundaram.
Yes.
State of Bihar case.
Yes. Here, my lord, paragraph 3, my lord, provides that, my lord, if it is not, my lord, they file any complaint, my lord, case, my lord.
Page, paragraph?
Paragraph 3, my lord.
3. That's all? Okay.
And my lord, in the, my lord, Jagdish Pandey, my lord, judgment, my lord, it is also quoted, my lord. It is their primary duty to issue, my lord, notice.
Which page?
My lord,
Which-
this, my lord, in my additional affidavit, my lord, page 84, my lord. Running page 84, this is
84.
page 84 in the running page, my lord, in my pleadings, my lord.
Yes.
Paragraph 26 of that judgment, my lord, quoted. May I state, my lord,
Yes.
page 84? Paragraph 26. Again, in Harish Singh versus State of Bihar, this court held that since the government had never put the employee on notice to indicate the date of birth as entered in the service book was incorrect, though it could have done so, and since no notice had been given to the employee concerned for accepting a date of birth other than one entered in the service book, the order of retirement could not be sustained. From the aforesaid decision, it is evident that it was the duty of the state to put the employee on notice about his date of retirement, and not having done so, the appellant was not held to recover the excess amount paid to the death fund.
But here the service
is-
book was all along with you. How could they know that
lord,
you are retiring?
But with all respect, my this is they are obviously they will say so before your lord. I was submission, my lord. Otherwise, they will be held guilty, my lord. How, my lord, teacher will keep, my lord, personally, my lord, in his custody, my lord. It is unbelievable, my lord, and it is not beyond the rule, my lord. How, my lord? It is impossible, my lord. Always employer should keep it, my lord. Block, my lord. And we also, my lord, little bit know the procedure, how, my lord, payment in the LP school is paid, my lord. It is always, my lord, block elementary education.
Yes.
But the
Mr.
petitioner has, the
Yes.
petitioner has not denied the same in the affidavit that is submitted by the.
The
but it
denied
is sorry-
specifically denied, my lord. My reply, my lord, I specifically denied, my lord, and said, my lord, if
So
it
Devi
is-
wanted to say something?
For hearing it, your lordship, so since it access wave matter, so I have gone through that director of pension is very important. Her name is not shown, so lordship here in this particular case, your lordship. Accordingly, some similar matters, namely Tarun Burman, Baharul Islam. The petitioner seeks for the waiving of the excess royal. After that, they again claims for the pension amount for that period,
You cannot.
for that overstay period.
You cannot.
No,
you cannot-
rightly, wrongly, they have availed their order. Now contempt is also going on with regard to that. So what
No,
we
you
fi-
cannot get both. You cannot get pay as well as pension.
so I humbly pray that this Torun Burman, Baharul Islam, and this particular matter, because it seems to be hand in glove. I'm very sorry to say that it seems to be hand in glove, because in one matter it may happen, but in series of matter this can't happen. And recently in the coordinate bench, one Burman, Torun Burman, when the records were called for, overwriting for that particular code also observed the same. So let all this be clubbed together and be taken. That is my
No,
point.
no,
Humble.
we'll decide this. Even if we decide in favor of the petitioner, we'll make it amply clear that a person cannot get salary as well as pension for both the periods. If you are giving him, if this court directs for salary till the period he works, then till that period the pension will not be counted.
Yes.
Pension will go after he is demitted office.
In pension manual, in pension book, it is basically made clear to OIM that the concerned employee, he has to be very vigilant, and he has to be very prior to retirement, he has to himself bring it to before to the notice of the authority. The authority may have vast work, but it is duty bound and specifically made
Right, it happens at times overstay is there.
because
But
these are
overstay-
they all are school teachers.
Overstay will not.
From day one, day comes when they will retire. This is practical. My learned senior is speaking about practice. From day one, they will count about there when they will go on retirement. And how this lectures can happen. And that way about from public sector 17, 18 lakhs per each person. So we have some.
He'll not get pension for that period. Obviously, he cannot get, nobody can get two benefits.
That is
Okay, please wait. The instant petition has been filed under Article 226 of the Constitution of India, challenging inter alia the action of the respondent authorities in purporting to make recovery from the pensionary benefits of the petitioner, an amount for which the petitioner had overstayed in service. Full stop para. As per the facts projected, the petitioner was initially appointed as a stipendiary teacher at Bongaon Mohidutta DUTTA LP School, Nalbari, on 22/12/1998. Full stop. In due course of time, he had passed the departmental basic training course and thereafter was granted the regular time scale of pay. Full stop. The petitioner contends that his date of birth was 1/1/1958 and therefore his date of retirement would have been 31/1/2018. Full stop. However, the petitioner had overstayed till 30/11/2021. Full stop. It is the case of the petitioner that for no fault of his, the overstay had occurred, and on its detection, he was released from service. Full stop. It is this period of service from 1/2/2018 to 30/11/2021, which forms the subject matter in which the salaries paid to the petitioner is sought to be deducted from the pensionary benefit. Para. I have heard Sri A.M. Barbhuiya, Learned Counsel for the petitioner. I have also heard Sri Ms. S. Chutia, Learned Standing Counsel, Elementary Education Department, whereas Sri B. Deori, Learned State Counsel, has represented the other official respondents. Para. Sri Barbhuiya, the Learned Counsel for the petitioner, has at the outset submitted that initially he had approached this court by filing WPC 2655 of 2022, which however was dismissed on withdrawal, as till that time there was no order issued for recovery. Full stop. He, however, informs this court that liberty was granted to the petitioner to raise the issue as and when arises, and therefore the present writ petition has been filed. Full stop. It is submitted that at the time of entry into the service in the year 1998, the date of birth of the petitioner was wrongly recorded as 1/1/1965 instead of 1/1/1958.
What, yes,
1/1/1958, full stop. He has submitted that such entry was made by the concerned officer and the petitioner, who had put his signature, was never aware of the same, full stop. He has also submitted that the petitioner had and he has also contended because he has also contended that the petitioner had submitted the original HSLC certificate to ascertain the date of birth at the time of entry into the service, in spite of which the error had crept in, full stop. He submits that the petitioner did not have any role in such incorrect recording of his date of birth in the service book, and accordingly, the attempt to recover the salaries for the aforesaid period from the pensionary benefit is not permitted in law, full stop. The learned counsel has also drawn the attention of this court to the affidavit in opposition filed by the respondent number 3 on 3/12/2024 and has referred to paragraph 4, wherein it has been stated that the service book of the petitioner was opened on 30/4/2007, and at that time his date of birth was wrongly recorded as 1/1/1965 by the then BEEO, Paschim Nalbari, full stop. He submits that from the aforesaid averment made in the affidavit in opposition, it becomes clear that the petitioner did not have any role in such incorrect recording, full stop. Para. The learned counsel for the petitioner, in support of his submission, has relied upon the case of State of Bihar versus so-and-so reported in AIR 1994, Supreme Court 599, in which it has been laid down that for the period of service rendered, no recovery should be made, full stop. For ready reference, the relevant observations are extracted herein below, paragraph 3. He has also relied upon the case of State of Bihar versus Pandey Jagadishwar Prasad, reported in 2009, 3 SCC 117, and the relevant observations are extracted herein below, para 26, full stop. In the said case, the Honorable Supreme Court had emphasized on the aspect of serving a notice prior to such action, full stop. Reliance has also been made on the case of Rafiq Mashi versus so-and-so, reported in 2015, 4 SSC 334, full stop. In the said case, the Honorable Supreme Court, after referring to the earlier case laws on the subject, had made the following observations, sir, quote Kurjin. Para. The Learned Council accordingly submits that the impugned action be interfered with and no deduction be made from the pensionary benefits. Full stop. Para. Per contra, comma, Ms. Chutia, the Learned Standing Council, has strenuously opposed the writ petition. Full stop. She has submitted that all along the service book was retained by the petitioner as well as the other employees of the school in question, and therefore it was not possible for the authorities to determine the date of retirement. Full stop. However, the particular BEO, Pasim Nalbari, had taken some initiative to verify the contents of the service book, and accordingly the service books were called for. Full stop. However, the petitioner was reluctant and delayed in handing over the service book, and even after doing so, the original certificate, original HSLC certificate was not given, and subsequently done by submitting a duplicate certificate in which the date of birth, from which the date of birth could be deduced as 1/1/1958. Full stop. Accordingly, immediate action was taken, which led to the petitioner demit office in the year by an order dated 29/12/2021. Full stop. She submits that the contents of the service book are required to be verified by the petitioner, and if at all some error had crept in while making such entries, it was the duty of the petitioner to point out the aforesaid error, and on the other hand, which he did not do, and on the other hand, the petitioner had served beyond the period permitted by law by knowing fully well that he had surpassed the age of superannuation. Full stop. She has also drawn the attention of this court to the communication dated 29/12/2021, whereby the BEO had written to the petitioner to hand over the charge, and also the communication dated 13/9/2023 issued by the Director of Pension to the Deputy Inspector of Schools, Nalbari, informing that the pension could not be finalized due to pendency of this case. Full stop. Para. Supporting the contentions advanced by the department, Sri Deuri, the Learned State Council, has submitted that the amount involves is public money, which the petitioner is not entitled to as per law, full stop. He submits that the rules governing the services clearly stipulates the the age of superannuation, and knowing fully well that the petitioner had surpassed the said age, he kept on serving without even informing the authorities, full stop. He accordingly submits that the recovery which is sought to be made is in accordance with law and should not be interfered with, full stop. Para. The rival submissions have been duly considered and the materials placed before this court, including the service book, which has been produced by Ms. Chutia, have been perused. Para. From the materials available, including the contents of the service book, it appears that the date of birth of the petitioner was recorded as 1/1/1965 when the service book was opened sometime in the year 2007. Full stop. The HSLC certificate, which is a part of the present proceedings, appears to be a duplicate one, as per which the date of birth can be deduced to be 1/1/1958. Full stop. Therefore, there is no manner of doubt that the petitioner ought to have retired on 31/1/2018. Full stop. However, as a matter of fact, the petitioner continued in his service, and it was only in the year 2021 when the authorities had detected that the petitioner was overstaying in service and had accordingly issued the letter dated 29/12/2021 directing the petitioner to hand over charge. Full stop. The grievance of the petitioner, as observed above, is the action of the respondent authorities to deduct the amount paid for the period 31/8/2018 to 29/12/2021 from his pensionary benefit. Para. The entries in the service book are required to be renewed and reattested every 5 years, which appears from the footnote of the service book itself. Full stop. A perusal of the service book, which has been produced in original, would, however, reveal that the entries were made by the Dan Block Elementary Education Officer. Full stop. The aforesaid fact has also been clearly admitted by the respondents in their affidavit in opposition filed on 3/12/2024, the relevant part of which is extracted here in below. Page 108, paragraph 4, quote করে দিব। Para. The petitioner has contended that he was not aware of a wrong recording of the date of birth as 1165. Full stop. However, the HSLC certificate which was furnished to the authorities, though duplicate, reveals that his date of birth is 1958. Full stop. There is no attempt on the part of the petitioner to justify that his date of birth was 1965 and not 1958, for which he was given a scope by calling for his service book, which was stated to be in the custody of the employees of that school. Full stop. Though it is the contention of the respondents that there was delay on the part of the petitioner to submit the service book to the authorities, there is no dispute to the fact that in the HSLC certificate, within bracket duplicate, submitted by the petitioner, the date of birth appears to be 1958. Full stop. The aspect of overstay in service has been the subject matter of litigation, have been subject matter of dispute in a catena of cases. Full stop. Para. In the case of Narasimha Supra, the Honorable Supreme Court had taken into consideration the aspect that in the period of overstay, whether the incumbent had rendered service would be a relevant factor. Full stop. The requirement of issuing a notice to the employee by the authorities has also been emphasized by the Honorable Supreme Court in the case of Pandey Jagadishwar Prasad bracket Supra. Para. In the case of Rafiq Mashi, the Honorable Supreme Court has laid down the parameters which are to be followed in cases of an attempt to recover for any overstay in service. Full stop. Para. In the instant case, only because, no, even in the instant case, even if the projection made on behalf of the respondents that the service book of the petitioner was in his custody is to be accepted, that will not reveal that any previous attempt was done for verifying the date of birth of the petitioner, which was recorded as 1965. Full stop. Admittedly, the service book was opened in the year 2007, and there is a mandate for renewal and reattestation of the same every 5 years. Full stop. In fact, a perusal of the same would reveal that from time to time there were further entries made in the year, namely in the year 2009, from time to time now. Last time, further. From to no, no, from that a further verification was done in the year 2009. Full stop. This court has also noticed that in the present proceeding, there is an order dated 9/4/2024 passed by this court, whereby an interim protection was granted to the petitioner till the pendency of this writ petition. Full stop. At this stage, Sri Deuri, the London State Council, has expressed a concern that there are instances when employees who had overstayed are also claiming not only the salaries for the period of overstay, but also the pension for the same period. Full stop.
Along with the provisional pension.
Pension, including provisional pension. Full stop. Para. After considering all the facts and circumstances, as well as the contentions advanced by the London State Council, expressing his concern for the public exchequer, this court is the opinion that the interest of justice would be served and the equities would be balanced by passing the following order. Para. The action of the respondent authorities to recover from the pensionary benefit of the petitioner for the period of overstay, namely 31/1/2018 to 29/12/2021, is interfered with and set aside. Full stop. It is, however, made clear that for the said period, the petitioner would not be entitled to any pension or provisional pension, and his pension would be calculated only from his actual or from the date when he had handed over service, that is 29/12/2021. Full stop. The following direction has also been passed by also taking into consideration that it is not in dispute that in the aforesaid period, the petitioner had actually rendered his service. Full stop. Writ petition accordingly stands allowed in the manner indicated above. The service book is returned to Miss Chutia, the London Departmental Council. Diploma.
Item 3 and 4.
With regards to item number 3, my lord, yesterday I have submitted, I have served copy in affidavit reply to the respondents, my lord.
You have filed yesterday.
Yes, ma'am. I
It-
have served copy today. I'll file. Objection.
Today will be filing.
Today will be
Rejoinder affidavit.
rejoined affidavit.
You
Today
file it, we
affidavit
can have it on Friday if you possible.
Yes, my lord. The
Mr.
date
Nath,
will
you're
be-
for whom? Private respondent. You tell us when.
No.
Selection committee.
No, that is, we are not on the merits. Madam has said that the rejoinder affidavit So a copy has already been served, so we'll be filing today. Let it be on records, we'll consider.
No, no, it's not on record, mother. I have only.
No, let it be on
Yes,
records.
sir.
We'll consider it since they are filing it. 1 or 2 days will not make any difference. Tell us when. We can have day after tomorrow also.
No, my lord, at least as my senior will appear in this matter, at least 2 weeks I may be given.
23 matter, not 2 weeks. We'll have it next week then.
This was long pending matter, my lord, and the
Well,
college.
next Wednesday.
suffering, ma'am.
Next
Right.
Wednesday.
My lord,
Okay.
next Wednesday will be. My lord,
Not tomorrow, not tomorrow, next Wednesday.
Can it be on 13th, my lord?
13th of June.
Today is what? Today is
Today's
3rd. 3rd. We can have an 11th. What is the problem? 13th you want? We
Yes,
can
sir.
have an 13th.
Well,
1-3, Friday. Okay.
Well.
Uh,
interim may be continued.
Heard MS S. Borpatro Gohai Learned Counsel for the petitioner who submits that the rejoinder affidavit would be filed during the course of the day. Full stop. Also heard Sri S.
Yes,
Das, Learned Standing Counsel, Higher Education Department, as well as Sri D. Nath, Learned Counsel for the respond number 7. You are appearing. Who are 3 and 5? Principal of the college.
College.
Name, your name. You are appearing with somebody or? SP sir, your name is there or not? Not there. Sri N. Sharma, Learned Counsel is present for the respond numbers 3 and 5. Para? Let the in view of the aforesaid submission, the matter is adjourned to be listed on 13th of June 2025. The affidavit which would be filed today be tagged with the records. The rejoinder affidavit, huh? Okay. Right. The interim order passed earlier to continue till the next date of listing.
Right.
Both 3 and 4.
I have my rejoinder for only item number 3, my lord.
And the rejoinder in WPC 2656, huh? Okay. दोनों में एक ही होगा. One order in both. Okay.
Early order.
Yes.
May I please, your lordship?
Yes.
In this case, I have a 3 prayer. Petitioner is a retired principal. After retirement from service, lordship, he got the GIS, DCRG, leave salary, etc. They are also getting pension. But in respect of DCRG amount, it was not paid. Now I got the same after filing of distribution. In 1 month salary, that is in the month of January 2021, it was not paid. In spite of there is a direction of this number code. And other prayer is that while I am serving as principal lordship, I used my own money regarding midday meal. And it was admitted fact, also respondent to comment admitted that some money I have used. And after retirement, it was released to the school, but the school authority did not refund it to me. That is my case. Your lordship will find on
Madam,
99.
sorry, what do you say?
Lordship, regarding the salary, your lordship 1 month salary, the proposal was sent by the inspector of schools, the director, your lordship. But because we actually, the director has asked the IS to give a copy of the service book here. But however, the service book is not with the authority. The petitioner has submitted the service book to the pension department, and it is with the pension department. It is because we do not have a copy of the service book, we are not been able to proceed with the
You procured it from the pension department. Your
lordship.
department, you asked for the copy. You cannot put the blame on him.
Lordship, we had a talk with the pension department, and pension department has said that the petitioner has to give his signature and then he can get the pension.
He'll cooperate, not a
I-
problem. Now, what about the midday meal? That can be sorted out. 1 month salary.
Regarding
Midday meal is concerned.
Who are you, mister?
I am appearing for decimal 7 and 9. But
every allegation against him.
found that
Who are 7 and 9?
Principal and 9 also.
You are also the principal.
I am retired principal.
Oh.
He is the presently holding.
Principal.
Is he entitled to midday meal?
No.
No.
Department says I am entitled.
As per my lord, audit report, he prepared false voucher. It is there, it is not, I need to audit report, my lord. Only.
You have to file a suit. If it is disputed by the president.
Question is that,
Audit report disclosed, my lord,
my
Then-
lord,
that it is also noticed that above transaction were made without the approval
Mr.
of
Borbia, the
SMC.
problem is that if we make any observation
Lord,
of Mr. Ahmed
here is that
regarding some fraudulent practice, you
every,
will not, will say the disputed questions, you may approach this.
And moreover, my lord, that has happened during his.
I
period,
have
my
one
lord.
submission, Lord.
That time, but he was the principal. I am just taking charge 2021 after his retirement. Those transactions have been made during his period. My lord. I am not responsible. I am not able.
Lordship, kindly see the department
And
affidavit.
for his 1 month salary, because he
And-
is not cooperating with the.
Okay,
us, my lord.
okay. 1 month salary will take care.
And court directed it to be paid
How much is the midday meal amount?
midday meal more than 2 lakhs, Lordship, and authority admitted it was subsequently released, and there is allegation against it, there is inquiry, he misappropriated the money. And even direction to place in suspension, DP may be initiated
Against Mr. Ahmed?
against Ahmed. There is an affidavit of the government.
It is, that
It is
evidence,
not
I
my-
have not got the copy, but that's now I produced the record.
There is
I
the
think that
affidavit of
that
government.
affidavit is not related to me, my lord, because this place the actual fact. Entire thing has been done during his period, my lord. He is the responsible. He has not submitted his bill himself, my lord. Just.
He's saying that you were about to be suspended and DP initiated against you.
No, my lord.
There is an
It is.
Where is it?
affidavit.
Where
It
is
is the
it?
affidavit filed by the.
Yes, Lordship, kindly see
It is the affidavit filed by the respondent 4.
paragraph.
SSF filed, my lord.
Yes.
That
Yes.
he was requested the authority to place me under suspension because record is there. Record found that there is no fault on my part. Even he did not cooperate with us. He did not give his pension book, everything, nothing.
Okay, we'll ask
My
the authorities to finalize this matter of midday meal.
My lord,
Mid-
If whoever is at fault, they should be punished,
my lord.
and whoever is entitled to the amount should be paid.
Yes.
And 1 month you'll be paid.
Yeah.
But you cooperate.
Lordship,
And just to page 43, lord, just a moment.
but-
Page 43 order at audit report, my lord.
43.
43, my lord.
Okay.
This is audit report. Read petition, 43, my lord. He say the loan has been taken from the principal. Is lordship can page 43, paragraph 2. Loan from principal.
Okay.
Lordship can drop
Okay,
down.
okay, we have understood your case.
Yeah. So,
Please have your seat. Okay.
page 43. 4.2. Loan from principal.
Yes, we have seen.
Now, later part, my lord, it was also noticed that the above transactions were made without the approval of SMC. As such, audit helps to ascertain the genuineness of the transaction from the above.
Okay, okay.
It is
okay.
revealed.
Okay, we'll take care. We'll take. Have a seat, please.
and Lordship,
Heard
department affidavit is there.
heard Sri F.U. Borbia, Learned Counsel for the petitioner. Also heard Miss Amusari, Learned Counsel for Learned State Standing Council, Secondary Education Department, semicolon Sri J. Ahmed, Learned Counsel for the restaurant number 7, 8, and 9.
No, not 8, 7 and 9.
7 and 9. Who is 8?
8 is SMC.
Okay. SMC who is appearing?
No,
Yes, madam. AG. You're for it's your senior. Who? Okay, what is your name? R.R. Sinha. Saikya. R.R. Saikya, London Council, appearing on instruction of Sri S.K. Methi. Standing Council, AG, Accountant General. Yes.
One page 67 of the department affidavit, there maybe looked into it.
What is there?
Page 67, paragraph 2. Audit report and inquiry, Lordship. That concern present
Okay,
balance, it is to
don't worry.
Ah.
As per the facts projected, the petitioner had superannuated from service as a principal of the Mugdi MUG Declina, Milan HS School in the district of Nalbari on 31/1/2021. Full stop. Though the petitioner had received his leave salary, GIS, DCRG, provisional pension, as well as regular pension, he was not paid the GPF amount of rupees 9,30,893 and also the salary for the last month, that is January 2021, amounting to rupees 90,492. Full stop. It is also the case of the petitioner. Yes, anything?
So, my lord, for the four.
BTC.
That
Assistant.
affidavit also filed.
You are Borua? B Borua?
It's-
H Borua? इनका भी नाम लिख दीजिए. On behalf of B Chaudhary for SSA. ठीक है, okay. उसका क्या, what did you write last? That I didn't get me. That he had utilized his own money amounting to rupees 2,52,019 for midday meal, which was per the instruction of the SMDC, with a condition that the said amount would be refunded. Full stop. However, the same was not done, and accordingly, with these causes of action, the instant writ petition has been filed. Full stop. Para. At the outset, Sri Borbhuya, the learned counsel, has informed that during the pendency of this case, the GPF amount has been released to
Yes.
him, and therefore the present dispute is with regard to 1 month's salary and the amount the petitioner had spent for arranging the midday meals. Full stop. He has submitted that both the amounts are entitled to by him. Full stop. As regards the amount pertaining to the midday meal, the learned counsel has emphasized that the petitioner had utilized his own money only for the interest of the school and as per instruction of the SMDC, and therefore the authorities are duty bound to replenish the said amount to the petitioner. Full stop. He has also submitted that the amount is sanctioned by the SSA, and he apprehends that the amount would be misappropriated. Full stop. Para. Ms. Musari, the learned standing counsel, has submitted that so far as the salary for the month of January 2021 is concerned, the department had indeed taken up the issue as the documents connected to the service records of the petitioner are presently with the pension department. Full stop. She has also informed that unless the petitioner's signature is given in the aforesaid records, the said aspect of releasing the salary for 1 month would not be possible. Full stop. As regards the claim for the midday meal, the learned standing counsel has submitted that from the pleadings exchanged, it appears that there are disputes raised as to whether the petitioner had actually spent his own money. Full stop. She has also informed that there was some kind of an inquiry made which appears from the records. Para? Sri J. Ahmed, learned counsel for the respond number 7 and 9, has strenuously opposed the claim for the midday meal amount. Full
I
stop.
joined only on 30 January 2022.
He submits that the respond number 7
Seven.
had joined the service in the year
30 January 2021.
in January 2021, and has also drawn the attention of this court to the audit report,
Yes.
as per which the genuineness of the transaction said to be made by the petitioner has been doubted. Full stop.
No approval has been taken from the SMC.
He has also submitted that the
There is no
records
resolution.
records do not reveal that any approval was taken
And there is any resolution
from
of
the
that.
SMDC, and there is no resolution in that regard by the SMDC. Full stop. He has also alleged that false vouchers have been submitted by the petitioner in support of the aforesaid claim. Full stop. Para. Sri Borbhia has categorically refuted the aforesaid allegation and has reiterated that the vouchers which he had deposited, which he had submitted, are genuine, and everything was done in a transparent manner. Full stop. Para.
And in the inquiry report, it has also been reflected.
He has also referred to the inquiry report, according to which inquiry report, and submits that the contention of the petitioner appears to be fortified, appears to be substantiated. Mr. Para. After hearing the parties and on perusal of the records, and also the fact that substantial relief in the form of the GPF amount has already been released to the petitioner, comma, there is no reason as to why the writ petition should be kept pending. Full stop. As regards the remaining claim, it is directed, remaining claim pertaining to the aspect of 1 month's salary and no. The dispute accordingly boils down to the aspect of the claim of the salary for January 2021 and the amount of rupees 2,52,019 for the midday meal. Full stop. Para. As regards the claim for salary for the month of January 2021, it is directed that the department, elementary education department secondary education would make necessary correspondence with the pension department by taking the petitioner, by involving the petitioner, so as to ensure that the signature of the petitioner can be put in the service book, in the documents, wherever it is necessary. And in this regard, the petitioner would render his full cooperation. Full stop. Thereafter, the amount be released to the petitioner. Full stop. The entire exercise be conducted and completed within a period of 45 days from today. Full stop. As regards the claim for the amount pertaining to the midday meal, comma, it appears that the aspect is a disputed one, full stop.
Yes.
While the
Affidavit-
petitioner,
Government affidavit that is.
while the
there is-
petitioner has contended that such expense was made by the, as per the instruction of the SMDC and in the interest of the school, the present principal has disputed the said claim,
Because I was not on that.
said claim on the basis of the records and which have been observed above, full stop. In view of the above, comma, the department, the SSA which releases the money in consultation with the secondary education department would make an inquiry on the same, and if it is found that the petitioner had actually spent the money for the purpose of midday meal, the same be released to him, full stop. If however it is found that such claim was made on the basis of forged documents, comma, appropriate legal action be taken in accordance with law.
Hello.
The petition accordingly stands disposed of.
Obliged.
May I please, Your Lordship?
Yes.
Lordship, matter pertains to family pension, Your Lordship. The petitioner is a 80 years old ailing lady, Your Lordship. Seeking, Your Lordship, because the husband, Your Lordship, the deceased husband of the petitioner, Your Lordship, was a assistant teacher of LP school, Your Lordship, who got retired in the year of 2012, Your Lordship, and expired in the year of 2018, Your Lordship. After that, Your Lordship, we have been continuously approaching the concerned authority, Your Lordship, for releasing of my family pension that have not been released, Your Lordship. So in the meantime, what happened, Your Lordship? The respondent number 6, Your Lordship,
Yes.
was the second wife of the
That is true.
Hmm.
And I have filed affidavit.
Yes, Lordship. This
Yes.
is employee, Your Lordship.
And I am the sister, of course. She is the elder sister. I am
Okay.
third sister.
Yes, then.
Both the
Your Lordship, on the last occasion, Your Lordship, the respondent number 4, Your Lordship,
Hmm.
filed some instruction, Your Lordship. Some instruction, Your Lordship. That is the Director of Pension, Your Lordship. That instruction reveals, Your Lordship, that is the purported to be affidavit sworn by me, Your Lordship, whereby I have declared, Your Lordship, that if the pension has been sanctioned to the respondent number 6, I have no objection. But I have denied the fact that is not my signature, Your Lordship. I basically use my thumb, Your Lordship, that is my not signature, Your Lordship. And Your Lordship, on that regard, Your Lordship, on the basis of that affidavit, Your Lordship,
It's off code, yeah. Yes. Yes.
on the basis of that affidavit, Your Lordship,
Hmm.
the Deputy Inspector of School of Buxa, Your Lordship, forwarded an application, Your Lordship, to the respondent number 4, that is Director of Pension,
Hmm.
stating that, yes, Lordship, one affidavit has been sworn by the petitioner that I have issued NOC in favor of the respondent number 6. But it is not true, Your Lordship. On the earlier occasion also, I have denied the fact that is not my signature, Your Lordship.
Okay.
That one is the first one, Your Lordship. Lordship, on the same ground, Your Lordship, the respondent number 6 has filed their affidavit. Same thing, Your Lordship, they have relied on the affidavit and the later, Your Lordship, forwarded by the Buxa, Lordship, Deputy Inspector of School, Your Lordship. Your Lordship, I have, on the last occasion also, the Honorable Court relied on, Your Lordship, one judgment, that is GL Bhatia versus Union of India and another, Your Lordship, reported in 1999, 5 versus 37, Your Lordship.
Yes.
If I hailed it, Your Lordship, right to family pension, Your Lordship, cannot be declared by making a nomination, Your Lordship. Irrespective of the affidavit, Your Lordship, the respondent number 6 is not entitled for the same, Your Lordship. That is my prayer, Your Lordship. And the petitioner is a 80 years old ailing lady, almost on a dying bed, Your Lordship.
Yes. Department.
only that. Yes, I'm.
Department.
But that was sad. One part. During the last the fact that the second part.
Not until, no.
As the instruction is from Director of Tax.
Hmm.
The first side is that for the
No, there would be no dispute or ambiguity with the aspect.
Yes, Lord.
And the legitimacy of the children would not be in question.
Yes.
But it is the first wife, unless they have some kind of a agreement
That
between
is-
them.
Yes.
But that is not asked for the release. Release
Yes.
part will go to the first wife. Thereafter, they may share, they may divide. It is up to them.
And my lord, she also admitted, para 12 matter, she also stated that if I'll get the pension, half of the pension, she has no. Kindly peruse the
What
para
happened, Your
12.
Lordship? I'm disclosing that fact.
That the
No,
petitioner begs to state
it
that.
is up to you.
No, that the petitioner begs to state that petitioner is in all occasion filing repention stating if the family pension has been equally
What happened,
appreciated
Your Lordship? in
between the
this doc-
parties and the respondent seeks and does not have any objection and but same is unheard of.
When Your Lordship, if Lordship permits, out of frustration, Your Lordship. Because since the year of 2018, Your Lordship.
You have
the-
issues. How many issues do you have?
We have, Lordship, 3 issues, Lordship.
You have.
One
Mr.
is visible, Your Lordship.
Madam
One
Devi,
is-
how many issues do you have?
We have
All are major, Your Lordship.
all are major.
All are major. So 136 and 143 bars the same, Your Lordship.
My lord, I have annexed 31 in affidavit.
Okay.
Office of the Gampura,
Hindu Marriage Act Council.
35. my lord. First family is my lord relation. Ajit Brahma, Anjumani Brahma, Bordeaux is
That will not
Sure,
find, Your
yeah.
Lordship, in that.
second family is details mentioned. We have it 3. They have it 6.
Hindu Marriage Act, which
What was that?
okay. Yes, please have your seat. The subject matter of this writ petition is a claim for family pension. Full stop, para. As per the facts projected, the petitioner is the first wife of one Pabin Chandra Brahma, who was working as an assistant teacher of the Sairabari LP school in the, where is it? Kamrup district. Where is Sairabari?
Masalpur, Buxa, Your Lordship.
At Masalpur. At Masalpur. And had retired from service in the year 2012. Full stop. after such retirement, the husband of the petitioner was getting his pension, and he had passed away on 18/9/2018. Full stop. It is the case of the petitioner that on such eventuality, the family pension is required to be paid to the petitioner, more so when her name has been recorded as the nominee in the service book of the deceased government employee. Full stop. It is the case of the petitioner that her husband had entered into a second marriage with the respondent number 6, which was, however, during the subsistence of the marriage with her. And it appears that certain documents which were in the custody of the respondent number 6 were utilized, and accordingly, the petitioner was deprived from the pensionary benefits. Para. I have heard Ms. G. Bora, learned counsel for the petitioner. I have also heard Ms. D. Das Burman, learned state counsel for the official respondents, and Ms. K. Devi, learned counsel for the respondent number 6. Para. Ms. Bora, the learned counsel for the petitioner has submitted that it is not in dispute that the second marriage with the respondent number 6 was entered into during the subsistence of the marriage of the deceased government employee with the petitioner, and the parties being Hindus, such marriage is invalid in the eyes of law. Full stop. It is also submitted that the petitioner's name being given as the nominee in the service book of the deceased government servant, there is no reason for depriving the petitioner from her family pensions. Full stop. She has also informed that the petitioner is having 3 children who are
Six
unemployed.
children.
Huh?
6, Lordship.
You.
6
You are
children.
having 6.
6 children. No.
And you are having 3. Petitioner is having 6 children, and one of the child is mentally challenged, and therefore grave hardships is being faced by her in her day-to-day life. It is also contended that the petitioner is presently aged about 80 years.
80.
80 years.
And it is shown as is 65.
And it's a post affidavit, Your Lordship. I even
No, not
signed my
post one,
signature.
we
of-
know
No,
how
no,
much.
We'll in your contention we'll write.
Under
It-
the see make it no objection notary.
Okay, we'll
It is shown that her age is 65. It was put in the signature in the year 2020. And she knows how to put her signature because she's my sister, elder sister. We went to school when we were same.
You cannot be perhaps 80. Your husband retired in the year 2012.
Yes,
Unless you are much older than your husband,
As per
which is
record,
normally not there.
in her records, also, it seems to be 80 or
No, but husband retired in 2012.
Lordship. Maybe he's older than her husband.
How much older? 1, 2 year, 2 years, 3 years? You cannot be 10 years older.
Correct.
Okay, that is your contention.
Yes.
Appears to be your, huh? Presently 8 years. 8 years. Full stop. Para. Miss Bormon, the learned state council, has, however, contended that do as per the Assam Service within bracket pension rules 1969. The name of a nominee of a deceased government employee cannot be changed, and in the instant case, it is the petitioner's name which is found in the service book as the nominee. There is also an affidavit which was submitted allegedly by the present petitioner, whereby she had expressed no objection if the pension amount is given to the respondent number 6. Full stop. In fact, a copy of the said affidavit, we'll come to you. You'll come to you. Don't be impatient. We have not recorded your submission. And said affidavit, along with the forwarding letter dated 12/2/2024, issued by the Deputy Inspector of Schools, Mosalpur, to the Director of Pension, was also placed on record, placed before this court, which has been made a part of the records wide order dated 21/5/2025. Full stop. Para. Ms. Devi, the learned counsel for the respondent number 6, has submitted that the aspect that her client is the second wife of the deceased government employee is not disputed. Full stop. However, she relies upon the affidavit filed by the petitioner, whereby no objection was given if the family pension was paid in the account of her client. Full stop. She has drawn the attention of this court to the affidavit filed by the petitioner, which was notarized, which was duly notarized and signed by the petitioner in accordance with law. Full stop. She has also submitted that both the petitioner and the respondent number 6 are actually sisters, and she and her client is personally aware of such affidavit being filed. Para. Ms. Bora, the learned counsel for the petitioner, has stoutly refuted the aspect of submitting any affidavit making such declaration. She has submitted that the petitioner is illiterate and puts her thumb impression in all thumb impression, full stop. However, she points out that in the affidavit alleged to have been submitted by her client, the signature appears, which itself would prima facie show that the affidavit is a manufactured one. Full stop. She has also reiterated that as per law, the second wife, there is no concept of second wife under the Hindu Marriage Act, and accordingly, no pensionary benefits can be paid to such second wife. Full stop. The Learned Council has also relied upon the case of the Honorable Supreme Court in G.L. Bhatia versus Union of India, reported in 1999, 5 SCC 237, wherein it has been laid down that the right to family pension cannot be defeated by making a nomination contrary to the pension rules, and such nomination would have to be considered as inoperative. Full stop. She submits that even if the affidavit in question, which otherwise is disputed by her, is taken into consideration, that cannot override the mandate of the rules governing the field. Para. The rival contentions have been duly considered, and the materials placed before this court have been carefully perused. Para. From the pleadings exchanged and submissions advanced by the rival parties, it is not in dispute that the petitioner is the legally married wife of the deceased employee who had passed away in the year 2012. 12, correct? 2018. Full stop. In fact, the Learned Council for the Respondent number 6 has candidly submitted that has candidly admitted the aforesaid aspect. Full stop. Para. The Hindu Marriage Act 1955 does not envisage any second marriage, and in fact, one of the conditions for a Hindu marriage as laid down under section 5 within bracket 1 of the Act of 1955 states that neither party has a spouse living at the time of the marriage. Full stop. Section 11 of the said Act lays down that if there is a contravention of the aforesaid clause, such marriage would be void. However, section 16 lays down that children born out of void and voidable marriage would, however, be legitimate. Full stop. Para. In the instant case, there is another aspect as advanced by the Learned Council for the Respondent number 6, which is in the form of an affidavit alleged to have been filed by the petitioner full stop. The said affidavit, which has been made part of the records along with the forwarding letter dated 12/2/2024, as observed above, would however reveal that a no objection was given by the petitioner if the amount in question is paid in the bank account of the respondent number 6, full stop. Though the execution of the affidavit, the execution of the affidavit, however, is categorically denied by the petitioner, who further contends that she is an illiterate, whereas the affidavit contains her signature, full stop. Even without going to the aspect as to whether the affidavit said to have been filed on 19/10/2023 is a manufactured one, comma. The aspect that the petitioner is the first wife is not in dispute. Full stop. The parties being Hindus, comma, Hindus, and there is no concept of any second marriage. The respondent number 6, as such, cannot have any claim over the family pension, full stop. Full stop. Further, as pointed out by the learned State Council, comma, Rule 143 of the Pension Rules of 1969 does not allow change in the name of the nominee after the expiry of the government employee, and it is not in dispute that the petitioner was the nominee in the service book of the deceased employee, full stop. In view of the aforesaid discussion, this court is of
Just indicated that she has no objection if that's what we take.
in the affidavit.
No, in her petition, para 12. Can you peruse?
Okay.
She has written, because she has already been given NOC, that's why she has written that she has no objection.
Para 12.
12, in her petition. Petitioner begs to state that the petitioner is in all the occasion filing representation stating that if the payment pension
Is
has
it
been equally appreciated between the petitioner and respondent number 6, the petitioner was not has any objection, but this,
Yes, Lordship. That is.
she has no objection.
That is
K.
true.
Devika already.
But out of frustration.
She had also referred to the pleadings made in paragraph 12
Yes, fine.
of the petition, writ
Yes.
petition, wherein the petitioner has stated that she would not have any objection
Yes.
if the family pension
She
is
admitted
equally appropriated between the petitioner and the respondent number 6.
6.
So last minute, huh? So last was, what was the last? Is of the opinion that since the law holding the field provides for payment of family pension to the first wife, comma, the petitioner would be entitled to the relief claimed, full stop. Accordingly, the family pension is to be released to the petitioner, full stop. However, it is also clarified that if the petitioner and the respondent number 6 are in agreement, such pensionary benefits can be appropriated amongst them, between them, full stop. The writ petition accordingly stands allowed in the manner indicated above.
Obliged. Much obliged, Lordship.
It is your lordship. On the last occasion, I seek time, your lordship, to obtain instruction. Your lordship, this
Item
matter.
number 8.
Yes, your lordship. And he was seeking, he has not received his salary with effects from 26/2006 to 13/9/2006, your lordship.
You have not received salary.
Yes, lordship. And now here, your lordship, it is not Kamrup Metro, it should be Kamrup Rural, your lordship. So here, your lordship, on the last occasion, your lordship, yesterday also, your lordship, I communicated, your lordship, to obtain instruction, but they're seeking some time, your lordship.
Okay, get the, you appear for whom? Secondary education.
Yes, your lordship, I am appearing for secondary
Get the
education.
instruction.
Or your lordship, one representation is also there, your lordship. He made one representation that has annexed as annexure H at page 28. So your lordship.
No, you take the instructions.
Yes.
Representation disposal, that is not of order.
Yes, your lordship.
Okay. Heard,
Time may be granted. your
heard
lordship.
your Asboro. Heard Miss Asboro, learned counsel to the petitioner. Sarah. On the
No.
prayer of Miss P. Das,
Yes.
learned standing counsel, secondary education department. Further 2 weeks time is granted to have, to enable her to receive the instructions. Get the instructions.
Petitioner is retiring this month.
Okay.
I'm deeply obliged.
Mr. Lordship, again, your lordship, item number 6, my apology, your lordship, again, I'm mentioning the matter. A specific time frame may be given, otherwise the authority, your lordship, have to, a specific time frame, lordship, within 30 days, 60 days, any days, your
Now,
lordship.
have you fulfilled your norms of filling up
All
the
fulfilled
papers?
in that period, your lordship. I have already applied, I have already submitted all the documents.
The,
your lordship.
for the aspect of release of pension be undertaken and completed expeditiously and preferably within an outer limit of 60 days from today.
Lordship.
The petitioner would provide all cooperation in this regard.
Lordship,
In
much
the-
obliged, lordship.
In the name of
Petitioner only. Yes. Petitioner we have said.
Obliged.
obliged.
36. Only accommodation for today only.
Yes, he was making a mention in the morning. We are for today. So he is not well. Mr. Air Bhuya is not well. Okay.
We have also not received the instruction.
That we cannot help to 14 matter. In 2025, we cannot grant
After a
time.
week, my lord.
If you, in the meantime, if we can obtain, it's good. Otherwise, we'll go ahead. A prayer for adjournment has been made on behalf of Sri A.R. Bhuya, who on medical grounds. A.R. Bhuya Learned Counsel for the petitioner, on medical grounds. Considering the medical, however, though adjournment has been granted, considering that this writ petition is pending since the year 2014, the matter is directed to be listed for hearing on. We'll have it on 13th. Enough time.
Yes.
No, not 13th. Not 13th. Earlier. On 10th. 10.
Obliged.
Okay. 10th. 10 June. Mr. Sharma, come up on 10 June.
37.
Yes.
Please, your lordship, lordship, my senior is like in another court, lordship, kindly pass for the matter for
Who is your senior?
Mr. P. Mo.
Another court, why? A 14
He-
matter.
He is in a sessions court. For
Sessions court is more important than a writ petition in the High Court. And it has been adjourned from time to time.
Can it be taken any other
Huh?
day?
No, at 2 o'clock.
Actually, we have also discussed the fact.
You see the court record, 2 o'clock.
Yes, ma'am. They are.
All matters we are not going to adjourn. 14 matter, 2 o'clock.
Deeply obliged.
And madam, if your senior is not there, you have a look at the court records. Assist the court, 14 matter, probably there is nothing to be decided.
Matter. Does not.
Yes, next.
Item 38.
Yes, Kolita, what is this?
Yes. This is a matter pertaining to, my lord, area salary to the petitioners. The petitioners was joined in service from 95. to
Yes, Mr. Khatanir, who's there? Who will be appearing? Education Department. Madam Kaur, you will be appearing. Yes. Education. What is it, Mr. Kolita? Area salaries.
Yes, my lord, area salary to the petitioner. There's 8 numbers of petitioner. They were appointed from the year.
You are
90
still in service or you have retired?
My lord, petitioner number 1 is retired, my lord, and petitioner number 6, my.
Retired, 2 retired. How many petitioners are there?
There is 9 petitioners
9, 2 of them have retired.
Yes.
7 are remaining in
Yes.
service. Area salaries for how many months?
from 2012, my.
2?
To my lord, 2019 petition number 1 retired, my lord, and petition number 6, 2019, my.
But this writ petition was instituted in 2016.
Yes, my.
How can you make a claim after 16?
My lord, we are working, my lord.
No, if you are praying for a particular relief in the writ petition,
Yes.
it cannot go beyond the period when the writ petition was filed.
Yes,
You have to file, have you filed any additional affidavit that subsequently also you have not been paid? Mr. Khatoner, what is this matter?
This regarding illegal and irregular appointment of Dhemaji district, Dhemaji and Chittagong district. Subsequently, cabinet has taken a decision to accommodate those teachers who are initially appointed without any sanction, but they are continuing. So those teachers were subsequently accommodated as.
They are amongst those teachers.
Yes, madam.
Yes.
Some of them have already been given the benefit of accommodation by tutor and teacher.
Tutor,
Yes,
okay.
madam.
Now, are you insisting on the area salaries? You
Yes.
have already got the benefit.
My lord, area
In fact,
salary,
in the
they have not given area salary.
No, your initial induction in the service
Yes.
was not in accordance with law. But in spite of them, since you have been working for a long period of time, as a welfare state, they have accommodated you as tutors or teachers.
Yes.
On the condition that you will have to forego the.
Yes.
But if you are insisting, then, but other matters we have all disposed of.
yes, madam.
Yes, my lord, your lordship document is there, my lord.
Yes, what is it? Now, do you have instructions from your client to press this?
Yes, for area, my lord, for area, my lord.
Regarding area, they have already given an undertaking. Well, they have joined in a new. As
What
a
about
tutor,
your
madam.
undertaking?
They have given an undertaking also, madam, that they will not claim for the past benefit. In fact, in the first appointment order, it was mentioned, madam.
Where is the fresh appointment order? This perhaps is not the case.
Yes, my lord, is my lord.
No, you're the case which you're referring
Yes.
is
Oloka Kolita versus State of Assam, my lord.
That is a different case, madam.
that is not pertaining to Sibsagar.
Yes, madam.
Yes,
That is different, madam.
Oh, my lord, another case, my lord, Chittagong district, my lord, that is.
No, what about the appointment letter after
After
your
my lord,
confirmation?
yes, my lord.
This is not with me, my lord.
If he has got an appointment letter, you have to at least disclose the same and you have to make a challenge, independent challenge that this condition is onerous. We had to sign because we needed a service, but you can still challenge without a challenge being there. You have a copy of the.
No, but today I don't have.
You bring it at 2 o'clock.
Yes, sir. I'll try my best to
You
get
bring a sample copy. That will do.
sample copy. Yes, that I can
Sample
put in,
copy. But you have to, we'll record your statement that it's the same kind of an appointment letter which were afforded to the petitioners.
Yes, sir. That I can.
That much of undertaking you have to give. Okay. Come at 2 o'clock.
Yes, my lord. This case, my lord, Aloka Kolita's case, they have appeal, my lord, before division bench, my lord.
Aloka Kolita is for a different district.
My lord. He is also appointed as tutor, my lord. But my lord, court view that, my lord, his appointment never cancelled as assistant teacher, my lord. Then, my lord, case was regularized and if to direct.
No, Aloka Kolita's facts are.
That is completely different.
Facts are similar. Are the facts similar to your case?
Yes, my lord.
Your cases have been stated to be illegal appointment without any sanction.
Here also, my lord, that is, my lord, appointment is irregular, illegal. Aloka Kolita's case.
But was Aloka Kolita given a subsequent posting by an undertaking?
Yes, my lord, yes. If my lord appointed as tutor, my lord.
No, where is the undertaking here?
Yes. My lord, in appeal, my lord, that is, my lord.
Where is it?
My lord.
Mr. Khatuniar, have a look.
In Aloka Kolita case, my lord, I was the counsel. I appeared, my lord. In fact, we have filed a review also, my lord, and my lord was pleased to put a cost on us also, my lord. Here, my lord, the case was we have terminated Aloka Kolita in the year 2006, my lord, by issuing a proposed notice, and he had replied to it, my lord. But after that, my lord, that proceeding was never
that is
ended, my lord.
Not terminated, my
Okay,
lord.
take it up at 2 o'clock, okay?
Obliged.
Hey, teacher, lord.
Yes.
I take in the morning, an item was mentioned here, a series of items.
Yes.
Lordship, in item number 35, there is an interim motor operator. We were not aware of a mention being made that that's why we could not be present.
35 is a series interim order, if any, stands extended.
Deeply.
35 would record to side of
There was an interim order.
Oh, we'll come at 2 o'clock. Yes, have you seen this? We have a look at this. Only a sample, not pertaining to you.
Yes, madam. This is the appointment letter issued to all the place accommodated.
You see the marked portion where Mr. Khatuniar has marked.
The accommodated discharge will get the prospective effect from 01/11/2020 only, and she cannot claim any benefit whatsoever in respect of past service rendered by him or her prior to 01/11/2020.
So if that is the condition, unless you challenge that condition, adjudicating here may not be proper. We are not saying, we are not precluding you from challenging. That's a different aspect. We may consider, we may reject your, but we cannot preclude you from challenging.
As regards my lord, Aloka Kolita, my lord, he did not accept this appointment letter, my lord.
Okay.
That is the reason, my lord, it was allowed.
Kindly fix, my lord, after week I will, my lord, with my client, my lord.
No, what is there to contact 2016 matter? If this is we are assigning reasons. We are saying that this is the condition attached to your new appointment.
Yes.
After that, and these are subsequent developments. And after that, in fact, whether this can be adjudicated, that itself is a question.
Yes, my lord.
Have
I
you,
will-
have you amended the writ petition? Did not?
No, my lord, I will take proper instruction from my client, my lord, that they appointed to it, my lord, with affidavit. I
Not necessarily. You should have called your client with that. Is
Yes,
why you
yes.
had fixed at 2 o'clock. We'll have it day after tomorrow then.
Yes.
Okay. By that time, you also try to incorporate, have that,
Yes.
her appointment.
Yes,
Okay.
I obtained it.
Okay. Though this writ petition is of the year 2016, comma, both Sri M. Kolita, learned counsel for the petitioner, as well as Sri N.J. Khatoni, learned standing counsel, elementary education, secondary education, elementary education, pray for some time to obtain the instructions. Full stop. The learned standing counsel has in fact submitted that as per the clause attached to the press appointment letter, the present writ petition has become infructuous. Full stop. Para. Be that as it may, the hearing of this matter is deferred till Thursday next to enable the learned counsel for the parties to obtain instructions. Okay, Thursday.
Obliged.
1 and 3 was required, my lord. Here, ATR salary may be classified. 1 and 3, my lord.
1 and 3 what?
Yes, 1 and 3 was required, my lord, on 2019. They have never appointed.
How many petitioners are there?
Here, my lord, 9 petitioner, my lord.
Okay, for them, what do you do?
1 and 6, my lord, required.
1 and 6 may not be covered by this kind of condition.
Yes, my lord. There is a
Because they, before accommodation.
For the period they have rendered, you have to pay the salaries. You take instructions on it, okay?
1 and 6.
Okay.
Obliged.
Let us- Right.
Even there was a conditional appointment, thus petitioners, senior status of the informed that he has already obtained PhD. From the date of PhD, she will get those.
It is under process, my lord.
From the date of PhD, she will enter to otherwise, as per conditions, she has to fulfill that UGC's next date of PhD lordship. Now she is completing PhD.
Then
From the date of obtaining the PhD.
Only my case was that, my lord, at the time of the advertisement and during the process of the interview, the net and slip, that was not, my lord, imposed. That was come, my lord, by the order after 9 months of the, from the date of the recommend. That is my case, my
heard
lord.
Sri P. Mohanto, learned counsel for the petitioner. Also heard Sri K. Gogoi, learned standing counsel, Higher Education Department, whereas Sri A. Chamua, learned counsel is present for the UGC.
My lord.
Full stop. Para. In view of the subsequent development and as also agreed to by the learned counsel for the parties, comma, there is no requirement to go deep into the facts and issues involved in this case. Full stop. Para. No, para. However, the facts of the case may be put in a concise manner in the following manner. In a concise manner. Para. An advertisement was published on 28/2/2001 for appointment as lecturer in economics in the Tezpur College.
Tezpur College, yes.
In the Tezpur College. Full stop. The petitioner, who claims herself to be eligible in all respect, had participated in the SAID's recruitment process and was placed as the first nominee in the panel of candidates. Full stop. Accordingly, a resolution was adopted by the governing body on 30/3/2001 to appoint the petitioner, and the said resolution was forwarded to the authorities. However, by the impugned order dated 15/9/2001, the appointment of the petitioner was made conditional of clearance of net slat until such time the petitioner would be entitled to a fixed pay, to a pay scale of rupees 8,000 per month. Full stop. It is the case of the petitioner that such condition was imposed after the selection process was held and therefore not having the sanction of law. Para? On the other hand, Sri Mahanta, the learned counsel for the petitioner, has submitted that the advertisement in question did not envisage any such condition, and therefore the same would amount to changing the rules after the recruitment process had come to an end. Full stop. On the other hand, Sri Gogoi, both Sri Gogoi and Sri Chamua, the learned counsel for the respondents, have submitted that such requirement is a statutory requirement.
Your Lordship, even advertisement itself says that it was permitted, Your Lordship, the candidates having latest UGC norm.
Statutory requirement. They have also clarified that the advertisement itself contains a specific clause of requiring all aspirants to be equipped with the latest UGC requirements. Norms. Equipped with the latest UGC norms. Full stop. They have further submitted that requirement of net slat or PhD is a sine qua non for a regular appointment, which is in consonance of maintaining a decent standard, maintaining a standard in the higher education. Full stop. Para. The learned counsel for the rival parties have, however, contended that in the meantime, the petitioner has obtained her PhD and the said fact has been intimated to the authorities. Intimated? Have you intimated?
It is one intimated, my lord.
Has been
It is
intimated.
notified
to the-
also, my lord. He is under the regulation 2009. A course material after doing, my lord, he has obtained the PhD. my lord.
No, have you intimated?
It is intimated. It is Srimanta Sankardev University. my lord.
No, regarding your acquiring the PhD, have you informed?
Informal, it is under process.
Has intimated. And the process is on to regularize the appointment of the petitioner. Full stop. In view of the aforesaid development,
No, this
this-
record, my lord.
this court is of the opinion. He has also placed before this court the certificate issued to the petitioner by the Mahapurukh Srimanta Hankardev Vishwavidyalaya. Full stop. That is last stop. In view of the aforesaid development, this court is of the opinion that there is no existing cause of action requiring continuation or further adjudication of this writ petition. Full stop. Accordingly, the same is closed with a direction to complete the process of conferring the regularity to the service of the petitioner in accordance with law expeditiously and within an outer limit of 2 months from today.
I will indicate from the date of acquiring PhD. that-
Yes, yes.
Obviously,
Yes, sir. That is why I have
it is
given
needless to state
2030
that
is
such
a-
regularization would only be from the date of acquiring the qualification.
Valid. Valid.
Obligable.
Pass.